Question 366. The safety clause in most exclusive listing agreements entitles the broker to a commission if the property is sold even after the listing term expires, provided the A broker used his best efforts to procure a buyer during the listing term. B. Broker had shown property to at least 5 potential buyers during the listing term. C. Broker had negotiated with the eventual purchaser during the listing term. D. All of the above. Correct answer is C. Broker had negotiated with the eventual purchaser during the listing term. The safety clause, also known as a holdover clause or extender clause, in an exclusive listing agreement is designed to protect the broker. If a sale occurs shortly after the listing expires to a buyer who was introduced to the property by the broker during the term of the listing, the key element that triggers the safety clause is typically that the broker 1. Introduced the buyer to the property during the listing term. This often means the broker showed the property to the buyer, provided them with information about it, or otherwise had substantive contact with them regarding the specific property. 2. The eventual sale to that specific buyer occurs within a specified period after the listing expires. This period is defined in the listing agreement. While the broker's efforts are generally expected, the safety clause usually hinges on the connection with the actual buyer who purchases the property shortly after the listing ends. Question 367. The following would be factors affecting economic obsolescence in a particular area, except A. Zoning changes. B. Oversupply of properties. C. Inadequate number of electrical outlets in a home. D. Recession. Correct answer is C. Inadequate number of electrical outlets in a home. Economic obsolescence, external obsolescence, arises from factors external to the property itself and is usually beyond the control of the property owner. These factors affect the desirability and value of properties in a specific area. Let's analyze the options. A. Zoning changes. Changes in zoning can significantly impact property values in an area. For example, a change from residential to industrial zoning can negatively affect the value of existing homes. This is an external factor. B. Oversupply of properties. If there's an oversupply of similar properties in an area, it can lead to increased competition, lower prices, and longer marketing times, negatively impacting the economic viability and value of individual properties. This is an external market condition. C. Inadequate number of electrical outlets in a home. This is an example of functional obsolescence. Functional obsolescence arises from issues within the property itself, such as outdated design, poor layout, or insufficient features compared to current standards. While it reduces the value of that specific home, it doesn't inherently affect the economic conditions or desirability of the entire area. D. Recession. An economic recession can lead to job losses, reduced consumer spending, and decreased demand for real estate across an entire area, causing property values to decline. This is a broad external economic factor. Therefore, inadequate electrical outlets are a property-specific issue, functional obsolescence. While zoning changes, oversupply, and recession are external factors affecting the economic conditions of the area. Question 368. One of the key elements of determining the value of a property is demand. But for demand to exist, it must be accompanied by A. Professional appraisal. B. Purchasing power. C. Financing. D. Staging. Correct answer is B. Purchasing power. In real estate, demand refers to the desire and ability of potential buyers to purchase a property. While desire is important, it's not enough on its own to create effective demand that drives value. Purchasing power refers to the financial capacity of buyers to actually make a purchase. They must have the necessary funds, cash, access to credit, etc., to translate their desire into a transaction. Without purchasing power, there might be interest in a property, but no actual demand that can impact its value. Question 369. Which of the following statements regarding an offer to purchase real property is correct? A. The offer must be in writing, but the acceptance does not. B. The acceptance must be in writing, but the offer does not. C. Neither the offer and acceptance need to be in writing, unless the property price exceeds $1 million. D. The offer and acceptance must both be in writing. Correct answer is D. The offer and acceptance must both be in writing. California's Statute of Frauds, Civil Code Section 1624, requires certain types of contracts to be in writing to be enforceable. Contracts for the sale of real property are specifically included in this requirement. An offer to purchase real property, when accepted by the seller, creates a binding contract for the sale of that property. Since the underlying agreement, the sale of real estate, must be in writing to be enforceable, both the offer and the acceptance, which together form the agreement, must also be in writing. The writing requirement applies regardless of the property price. Question 370. An unlawful detainer action can be commenced by a landlord against a tenant when A. The tenant fails to leave upon the expiration of his lease. B. The property is sold. C. There is a month-to-month lease, and the tenant does not move out after a 30-day, 60-day or 90-day notice to quit. D. All of the above. Correct answer is D. All of the above. Here's why an unlawful detainer action, which is a legal process to evict a tenant, can be commenced in each of these situations in California. A. The tenant fails to leave upon the expiration of his lease. When a lease with a specific end date expires and the tenant remains in possession of the property without the landlord's consent, they become a holdover tenant. The landlord can then initiate an unlawful detainer action to regain possession. B. The property is sold. While a sale itself doesn't automatically terminate a lease, the new owner may have grounds to terminate the tenancy depending on the terms of the lease and California law. If the lease allows for termination upon sale, or if it's a month-to-month tenancy and proper notice is given by the new owner, and the tenant fails to vacate after receiving a valid notice to quit, an unlawful detainer action can be filed. C. There is a month-to-month lease, and the tenant does not move out after a 30-day, 60-day or 90-day notice to quit. In California, a landlord can terminate a month-to-month tenancy by serving the tenant with a proper written notice to quit. The length of the notice required depends on how long the tenant has resided at the property. 30-day notice if the tenant has lived there for less than 1 year. 60-day notice if the tenant has lived there for 1 year or more. 90-day notice in some specific situations, such as when the property is being withdrawn from the rental market under the Ellis Act. If the tenant fails to vacate after the expiration of a valid notice to quit, the landlord can proceed with an unlawful detainer action. Question 371. A real property seller can recover damages from a real estate broker if the broker A. Acts in excess of his authority conveyed by the seller. B. Makes a representation to the buyer authorized by the seller. C. Discloses a material fact to the buyer regarding the intended use of the property. D. Provides revised escrow instructions to the property's escrow agent. Correct answer is A. Acts in excess of his authority conveyed by the seller. A real estate broker acts as an agent for the seller, and their authority to act on the seller's behalf is defined by the listing agreement and any specific instructions provided. If a broker oversteps these boundaries and takes actions that were not authorized by the seller, and these unauthorized actions result in financial harm to the seller has grounds to seek recovery of damages from the broker. This could occur, for instance, if a broker disregards a seller's minimum acceptable price and enters into an agreement to sell the property for a lower amount without the seller's explicit consent. In such a scenario, the broker's actions exceed their authorized power and directly cause a financial loss to the seller, making the broker liable for those damages. Conversely, a seller would generally not have grounds to recover damages from a broker for actions taken within the scope of their authorized duties and legal obligations. For example, if a broker makes representations to a buyer that were specifically approved by the seller, The seller cannot later claim damages based on those statements, assuming the information provided was accurate. Similarly, a broker's duty to disclose material facts about the property to potential buyers is a fundamental aspect of real estate law and ethics. Disclosing information relevant to the intended use or condition of the property, even if it might influence the buyer's decision, is a protective measure for all parties involved and does not typically constitute grounds for a seller to sue their broker. Furthermore, a broker's involvement in the escrow process, including providing revised instructions to the escrow agent as the transaction progresses, is a standard and often necessary part of facilitating a real estate sale. As long as these instructions are made with the seller's knowledge or consent, or are reasonably necessary to complete the transaction according to the agreed-upon terms, they would not typically lead to liability for the broker. The key factor in determining a broker's liability for damages is whether their actions exceeded the authority granted by the seller and directly caused financial harm. Question 372. The State Attorney General's office would be legally required to become involved in which of the following cases? A. A real estate license applicant is accused of cheating on the licensing exam. B. A real estate developer is suspected of falsifying subdivision reports. C. A real estate broker whose license has been suspended sues to have the real estate commissioner's decision overturned. D. All of the above. Correct answer is D. All of the above. As the legal counsel for the Office of the Real Estate Commissioner, and by extension, the Bureau of Real Estate, the State Attorney General's office has a responsibility to represent the Commissioner's interests in various legal matters. This would indeed extend to all the scenarios listed. A real estate license applicant is accused of cheating on the licensing exam. The Attorney General's office could provide legal advice and representation to the Commissioner regarding the administrative proceedings and potential legal challenges arising from such accusations. B. A real estate developer is suspected of falsifying subdivision reports. This could lead to legal action initiated by the Commissioner or involve the Commissioner's office in investigations, requiring the Attorney General's legal counsel. C. A real estate broker whose license has been suspended sues to have the Real Estate Commissioner's decision overturned. When a state agency like the Bureau of Real Estate, CalBRE, formerly DRE, suspends a professional license, and the licensee challenges that decision in court, it typically involves a legal action against the state agency. The State Attorney General's office is the legal representative for state agencies in such lawsuits. Therefore, considering the Attorney General's role as the legal representative for the Real Estate Commissioner and the Bureau of Real Estate, they would be legally required to be involved in all of these cases to protect the Commissioner's interests and the enforcement of real estate law. Question 373. Which of the following is a recurring cost? A. Appraisal fee. B. Title insurance. C. Pest control. D. Recording fee. Correct answer is C. Pest control. Recurring costs are expenses that are paid on a regular basis, typically monthly, quarterly, or annually, throughout the period of ownership. Appraisal fee is a one-time cost paid at the beginning of a real estate transaction, usually when obtaining a loan. Title insurance is a one-time fee paid at the close of escrow to protect the buyer, and sometimes the lender, against future claims against the title. Pest control is not always monthly, but pest control services are often contracted on a recurring basis, e.g., quarterly or annually, to prevent or address pest infestations. Recording fee is a one-time fee paid to the county recorder's office to officially record the deed and other documents related to the property transfer. Therefore, pest control is the only option that represents a cost typically incurred on a recurring schedule after the initial purchase of the property. Question 374. The cost approach in appraisal relies on the following methods. A. Quantity survey method. B. Square foot method. C. Unit in place method. D. All of the above. Correct answer is D. All of the above. Quantity survey method involves breaking down the property into its component parts, materials, labor, overhead, and estimating the cost to rebuild it from scratch. Square foot method uses the cost per square foot to rebuild comparable properties to estimate the replacement cost of the subject property. Unit in place method assigns a cost per unit, e.g., per square foot of roof, per linear foot of plumbing, to various components of the property to estimate the replacement cost. Question 375. Prepaid rental listing agents are mandated to do the following, except A. Return the client fee if no referrals are submitted within 5 days of the agreement's execution. B. Provide a contract and receipt for every potential tenant, promising the return of their fee if certain circumstances are met. C. Submit an account statement to the Real Estate Commissioner on a quarterly basis. D. Refund any funds over $25 if a rental is not procured. Correct answer is C. Submit an account statement to the Real Estate Commissioner on a quarterly basis. Prepaid Rental Listing Service, PRLS, agents in California have specific legal obligations to prospective tenants. They are required to provide a comprehensive written contract and a receipt for any fees collected. The contract must clearly state the services offered and the total fee. It must also specify the conditions for refunding any portion of the fee over $25 if the agent fails to find a suitable rental. This refund provision is a key consumer protection element within the regulations governing PRLS operations. Furthermore, PRLS agents are mandated to maintain thorough and accurate records of their business activities. These records must be readily available for inspection by the Bureau of Real Estate, CalBRE, at any time to ensure compliance with the law and to protect consumers from fraudulent or unethical practices. While agents must be prepared to account for the funds received and how their services are utilized, there is no specific legal requirement mandating the submission of a formal account statement directly to the Real Estate Commissioner on a quarterly basis. PRLS agents are governed by regulations intended to protect prospective tenants. However, directly submitting a quarterly account statement to the Real Estate Commissioner is not a required part of these regulations. Instead, the focus of the law is on the contractual agreement with the tenant, the provision of services, the refund mechanism for unsuccessful rental procurement, and the agent's obligation to maintain inspectable records.